Lowe's knows how to turn big plans into real results. Whether it's new appliances or a home refresh, get started with 12-month special financing on purchases of $299 or more with a My Lowe's Rewards credit card, January 15th through the 30th. So you can invest in your upgrade now and pay over time. Lowe's, we help, you save. Offer subject to credit approval and cannot be combined. Minimum monthly payment required. See store or Lowe's.com for details.
Welcome back to Come Back with a Warrant podcast. I'm Brandon Dinitz.
And I'm Monica Ashak. Before we kickstart this week's episode, this is your reminder that this podcast is not legal advice. It's real, unfiltered, and for entertainment purposes only. If you need to speak with a lawyer, call one. Or better yet, call us.
So is the hardest part of being a defense attorney the law or managing clients?
Definitely managing clients.
Okay.
Definitely.
I mean, today's episode, we're going to be talking about client control and dealing with the emotions of others, especially our clients, because we take on a lot of other stress from other people when we do our job. And rightfully so, our clients come to us under a lot of stress because they are being accused of a criminal act of some sort. But we oftentimes become part therapist and part counselor and part advisor and part coach. And, you know, we get everything, every type of situation. And then we often have to deal with people that have mental health issues or substance abuse issues.
Yeah. And they all intersect at one point because not only is this criminal case, it could be related to a DUI or whatever it is that's substance related, or maybe there's a mitigating factor for why they acted in a certain way on that day due to their mental health. Aside from all that, just having to deal with the effects of it when you're counseling them in their case and then having to help them rebuild their life back into the community if, you know, they've lost their job as a result of getting arrested or their home as a result of getting arrested for a domestic or whatever it is. And so there's so many different points of intersection that we ultimately kind of get the effect or like the baggage that comes with it.
Right. I mean, and we take on, you know, everything from manic episodes of our clients where they're cursing us out and really angry. And then, you know, the next phone call with them, they're really apologetic or like it never happened. And you have to be able to tolerate, you have to others and handle everything with some empathy and also let it roll off your own shoulders, because taking on the emotions of your clients is unhealthy to a degree, because as much as I want to, you know, I understand how they're struggling, I understand how they're stressed, like that stress is not my stress. I have to always remember that and remember to not take that on. And also remember that when my clients are angry or upset with me, 9 times out of 10, it's not that they're upset with me. They're upset with the circumstance that they're currently in. Yeah. And I understand that because I know that the next time I talk to them when they're happy and they apologize to me and they, you know, explain to me, look, I'm just really going through a bad time. I get it. I understand, like, you know.
You don't hold it against them.
No, never.
And that's, I think, where, like, if you let your ego get in the way of, like, your relationship with your client, there can be so much trust broken there. And then you can't really even move forward and resolve the case together, because the point is that you're a team and you can't get certain things done in your job, whether you're presenting mitigation to the state, without the assistance of your client, and vice versa. Obviously, they need you. That is like such a big point. I get random rage messages from my clients sometimes when they're having a bad day, and it will have sometimes nothing to do with me. Like sometimes about their probation officer, sometimes, you know, it's just random. That. And like, to me, when I get them, like, they're random. So I think it's kind of funny because I like don't expect it. I'm like, oh, okay.
Yeah.
But then I'm like, okay, they're probably going through something.
Right.
And we end up having a conversation about it. And it's not easy for them. So understanding, having that empathy, like you said, and being compassionate towards them. But my problem has always been, I've been too compassionate and empathetic to my clients. And I have let it get to me in the sense of like, I absorb it and it takes over. I lose sleep. I think about it all the time. You know, I wake up in the middle of the night, like, not anymore, but I used to like struggle with this because when I first started in public defense, I was 24. I didn't have much life experience. And I wasn't exposed to a lot of the people and communities that I was exposed to as a public defender, and I was still so young. And so having experienced certain interactions with my clients without having that knowledge or training from like law school or prior to that, it weighed on me. And so if you're not aware of the things that our clients struggle with and you enter the public defender's office or maybe even legal aid or other sorts of circumstances or jobs where you deal with a lot of trauma, you can get secondhand trauma just from being exposed to it and taking on the grunt of a lot of what your clients are going through. And so when I was working for a private attorney, criminal defense attorney, he told me like, you like basically care too much. Like we need to like have some boundaries. And at the time, thinking back, hindsight's 20. Thinking back, I definitely like my response was like, that's like my juice. That's like what keeps me going, which is true because I love what I do and I'm very passionate about it. But there are times now where my clients, like I need to have that conversation with them where it's like
setting boundaries.
We got to stop.
Yeah. And I was going to ask you is when do you know that it gets to the point where you need to start setting certain boundaries with clients?
Once we have the same conversation more than twice.
Okay.
Like once it's like I will let them have their therapy session one time. Once it comes up again, I tell them like, we're not doing this. Like, because oftentimes they are either like the first time it happens, they're either receiving information from me or from the situation that is affecting their mental state in real time. So because of that, I allow them to be human and experience the emotions that come with whatever information they're receiving that they feel like is so daunting. If it's like, if they're fixated on it, I'm not your therapist. Like I am here to legally guide you and counsel you on the best outcome and what we need to do next. But if you want to talk about this more, you need to pay for somebody else to listen to it because you're taking away from my time to work on your case legally. My job is to be your lawyer. So I just remind them that this is not my role. And if they need support, like resources, I'm happy to connect them, but that's not my job.
Yeah. So, I usually feel like once you get, as you called it, like a rage text session, and I'm understanding about that. And then after that, it's like, no, we're not going to do that. You're not going to talk to me that way. We're going to have a very, civil conversation because the role that I am here for is I'm not, your friend. And I'm also not paid by you to bullshit you. I tell that to a lot of my clients is you don't pay me to kiss your ass. You don't pay me to give you bullshit. In fact, you pay me for the opposite. You pay me to tell you exactly the way that it is, whether you like it or not, and make sure that I'm giving you all of the information that you need. And sometimes clients aren't ready to hear that, or they're in denial, or they're upset, or they're depressed. And you go through those different stages of grief with them and get them through to the other side. Often, people that are dealing with their first time being arrested are very, very nervous and concerned, rightfully so, because this is not something that they've ever gone through before. But we know what the process is going to be for them. So I'm able to not take on their stress load on a situation where it's like, somebody got their first DUI ever and they're thinking the world is going to fall all around them and they're never going to get a job and they're never going to get, anything. It goes right over, it goes right off my back. I don't absorb any of that anymore. But yeah, at the beginning, like I used to, like when I would have a client call me and say, hey, I have a warrant out for my arrest, I would freak out and be like, I need to get the order to recall this warrant like right away. Otherwise, it almost felt like I was the one with
getting
the warrant,
arrested.
And it's not healthy. You can't do this job effectively. Yeah. But I also have the other benefit of when I go home in the afternoon and I'm spending time with my family, like my son doesn't know what is going on with my cases or care about any of that stuff. So I have to completely turn that off because I'm not going to be stressed out about so-and-so's warrant when I'm playing with blocks with my son. Like, it's just not going to happen.
Yeah.
And part of I feel like it's partly a gift to be able to compartmentalize like that and separate all that stuff out. But with what we take on in a given day, yeah, absolutely. And I think there are plenty of attorneys that wind up embracing too much of the trauma and stress from their clients. And you can see it in the way that
It
they
shows.
argue in court.
Yeah.
When they're advocating strongly, but they're advocating also from a point of emotion, not just logic and law.
Becomes personal.
And you see that and you can tell like, okay, like you're taking on, and sometimes it's effective because it's like, wow, they're really compelling. But if they're doing it all the time, you're like, this is not a healthy way to live or run a business.
It shows for sure.
And I remember those attorneys when I was at the state, having cases against them when they were just so emotionally heated about nonsense and, small minor things in cases. You can see that they're adopting too much of the stress that your clients have.
Sometimes their clients try to put on so much pressure on us when it comes to making certain arguments, and they are not. So the ethical rules dictate who is to make the decision in certain cases, and specifically, or I shouldn't say certain cases, in all cases, but at certain points of the case. And specifically when it comes to strategy and making certain legal arguments, that is up to us because we are the lawyers, we are the experts, we know. But when it comes to life-affecting circumstances, such as, are you going to take a plea of guilty or not guilty and go to trial and risk the maximum or getting a minimum mandatory or whatever it is, those things are decided by the client and not us. We are the ones that are getting them to that destination. So we just present everything according to our expertise, what is the best outcome. But if they want to ignore it and they want us to argue, a random legal issue that doesn't exist in the case, we don't work for them. Like, that's not how this works. And so when you have an attorney that doesn't really see the distinction between who is the one that's really in control of getting the case to where it needs to be, and the client is the one to tell you which direction they want to go, that is when it becomes, I think, it turns into what you're describing.
Yeah. And if you let the situation get out of control by letting your client control the complete situation, you run into problems. Because when you have situations where your clients are thinking about conspiracy theories as to how they got arrested, and it's so off base, and I'm not talking necessarily people that are having mental health problems. I'm talking about regular people that'll say like, oh, this cop is dirty, or, the Irish mob had a hand in making sure I got arrested. When you hear, and which is something I've heard, when you hear random things like that, you have to be the one that's making the decisions. It's like, I'm not going down that avenue. Like, I'm not going to start looking into the conspiracy angles on your case and then present that to the state attorney's office as that's what's, going on here. You're just not going to do that. And that's really comes down to what you're saying, though, is we have to make certain decisions in the case, and strategy and the direction of the case, for the most part, other than the things you just said, that's up to us.
Yeah. And someone has to be the level-headed one. Someone has to be the one that is able to separate the law. And yes, while this criminal law violation affects so many areas of that person's life, we need to be able to see that this is a legal issue, or this is how I can help them legally or otherwise. And this is something I cannot control, to out of my hands. I've supported them in the best way I can, and they need to seek resources elsewhere. And so I think it becomes, and like, I don't mind that. I think, and like I said, a part of the reason why I love to do what I do is because I am helping people in circumstances that it's not just in the legal field, right? Like, I'm helping them rebuild their life, or I'm helping them get to a better place. And hopefully that is a part of what I love to do. But at the same time, it needs to be cut off at a certain extent, because I can't sit here all day on the phone and listen to you and why you're upset about the situation. I understand that. And that's why I need to get back to work and focus on your actual case. I was going to say, we had a case together and oftentimes we have to just like assure our clients that, it is fine. I got yesterday a call for an expired DL for more than 6 months. Yes, it's a misdemeanor, and this person had never been in trouble before, but oh my gosh, the stress they were enduring. I'm like, the fact that you got a notice to appear, which is in lieu of an arrest, you get a notice, go to court on this date. That says enough about the trajectory of where this is going. Like, do not worry. It will likely get dismissed.
Jail.
Yeah.
Correct. It is likely getting dismissed.
Yeah, you are facing jail time, like, on paper. Are you in a jail, especially in South Florida, for an expired DL?
No.
Like, please take a deep breath. Everything will be okay. So, like, you have to kind of have those, like, that was my conversation yesterday. And it was like, I don't know if that that could trigger some people. I don't care. But like, you need to know, like, that's a part of the reality. Just like on the other side of it, I have very serious conversations with my clients where they are like, get me probation. And I'm like, you have a 3-year min-man and we have no legal arguments against any of the facts alleged in this case. So we need to present mitigation and you need to get me something.
And
like,
you also need to start preparing for the idea that you're going to be spending time behind bars.
In custody,
right.
Yes. And at this point, we're talking, hopefully, getting the min-man waived. Like, there are so many different, like, conversations we have with our clients. And while we have hard conversations, the other side of it is we're telling them to calm the fuck down.
When I get bad news that I have to give to a client, and when I say bad news that I have to get to a client, usually it's the state attorney's office telling me what the offer is and then me having to relay it. One of the things I do is I try to do it right away because I don't want to delay it. I don't want to wait and do it. First off, I think they're entitled to the information right away, so I give it to them right away. And second, delivering bad news isn't fun.
It's not easy.
You got to get it. You got to do it.
Yeah.
So I get it done right away.
Yeah.
And I call the client and tell them, look, this is the situation. I lay it out exactly as is, and then I right away tell them what my next steps are, what my plans are. And if I don't have them, then I explain to them, these are the next steps, and this is what you can do from here. Meaning, if there's no way that I can mitigate it further or negotiate the deal to be better, then I lay out the 2 options where they can either plea or they can take it to trial and what a trial would look like and what fighting it looks like. But I make sure that I deliver that bad news right away.
Me too. I don't sit on it because it weighs on me until I'm like, it's like, oh, I still have to like do that. It's like just another thing I have to do, but it's another hard thing I have to do. And it's, like speaking it, like it's just a conversation. It's 5-10 minutes of our time or whatever, 30 minutes of our time. But it's not necessarily about the time. It's more about like the heaviness of what you're going to experience when you do talk to the client. And we're human. Like, while we can just like compartmentalize and keep our lives separate and not let it weigh on us in such a way that it would affect us, it still is something that we experience, and it doesn't mean that we don't feel anything, when we're
it's not easy to pick up the phone and have to tell people that they are going to jail. And that is what we're talking about when we talk about the hard decisions that we have. 9 times out of 10, if I'm saying I have to have a tough decision with a client, it's because I'm explaining to them the amount of jail time they're facing.
Or prison.
Right. And I'm not talking about it in a hypothetical, like, hey, you face a maximum of this. I'm saying like, you are being offered 5 years in prison. This is what's in front of you. This is what our defenses are. And this is what we can do. It's very heavy stuff that you have to get off your own plate right away. Yeah. There's no reason for it to sit around, and it's not going to be an easy conversation to have. No part of that process is easy, but that's necessary for us, and it's part of the job.
Yeah, and also doing it ASAP gives them time to think about it, consider it, sleep on it, because I'm like, do not give me an answer right now.
Right.
We'll schedule a call for next week, and we will talk about this again, because I understand you just received such heavy news, and you need to really think about what we just talked about. So, but on the flip side of things, because we were in county court, which is only misdemeanors, we had a case together.
Yeah.
And so we're talking a lot about risking it going to trial versus pleading guilty. And so Brandon and I had a first-degree misdemeanor case together, and this was actually my first trial. And my client was basically being offered a dismissal.
She was being offered a dismissal, not basically.
Yeah. And she just needed to sign.
She didn't.
She didn't
even waived that.
Okay.
So the bottom line here, I'll briefly tell this story, but Monica and I had a case. The person was charged with a first-degree misdemeanor, and they were hesitant to do anything other than fight the case and go to trial. I offered what is called a deferred prosecution agreement, which is basically a document that says if the person agrees to do something, then the state attorney's office will drop the case and dismiss it.
No guilty plea, nothing.
There's no admissions of anything. There's no guilty plea, no nothing. I agreed that this person wouldn't even have to sign that agreement, that Monica's signature alone would be sufficient. And if Monica signed that document, I was ready to dismiss it. So the only condition that had to happen was Monica signing a document that's basically said that the person agrees to complete conditions, which there was no conditions, other than Monica signing the piece of paper. And then I would have entered another piece of paper right behind it dismissing the case.
Yep. And I did not sign that paper.
And Monica did not sign that paper.
Yeah, we went to trial. We lost. The defense lost. Brandon won, or the state, I should say. But it was a victory for you. And my client got sentenced to jail from the judge. So she literally could have just walked out of the courtroom and called it a day, actually never have even come to court, but she wouldn't give me permission to sign the paper.
Lowe's knows how to turn big plans into real results. Whether it's new appliances or a home refresh, get started with 12-month special financing on purchases of $299 or more with a My Lowe's Rewards credit card, January 15th through the 30th. So you can invest in your upgrade now and pay over time. Lowe's, we help, you save. Offer subject to credit approval and cannot be combined. Minimum monthly payment required. See store or Lowe's.com for details.
She ended
what
up
do you
having
think
to
that's
face...
taught you about client control, and how do you think back on that now when you're dealing with cases?
So in that specific situation, so many people from the office spoke to that individual. So I don't think it would have even mattered in that scenario. But having had that experience as my first trial moving forward, it definitely made me explain that process to clients in a much simpler way, where they don't feel like they are admitting to something or giving something up as a result, especially for someone who had no criminal history, which she did not. That's part of the reason why you offered that. That could get off your record. You could expunge that. Like,
correct.
it's not something that will affect your life ever, And so she ended up having to deal with a very long process that I later wasn't assigned on the case, but I went back and looked, and I was like, I thought to myself, like, had she just like done what everybody advised her to do from our office, it would have been such an easier result, a better result for her, an easier experience, because that happened right before COVID, and the jails were overcrowded more so than usual. And it was just a whole whirlwind of issues that were going on surrounding that time. So in terms of client control, definitely just getting straight to the point. In the beginning, I didn't know how to do that. I was just like, oh, well, and I was scared shitless also to go to trial. So
yeah, I think that taught me as a prosecutor, and as a prosecutor, there was literally nothing else I could have done.
No, yeah.
As a defense attorney now that looks back on that, I think you hit the nail on the head. You have to be able to articulate why certain things are better than others, and why they are a win, whether that's, she was looking for just like an outright dismissal, which the case was already brought in, and the notice to appear everything was already filed. The case was already open. It wasn't going anywhere. It wasn't going to just be, there was no other mechanism to do what I was going to do other than what I did, which was how to dismiss that case for that person, which I thought was appropriate because I didn't think it was that serious of a situation. It was a misdemeanor for basically just interfering with an ongoing investigation. That's all that was going on. And I was using my discretion as a prosecutor at the time, but it taught me that you have to be able to talk to people about their pride when it comes to certain cases, because your pride can't get in the way if the long-term goal is for this to be gone. You have to be able to
look at the bigger picture.
Right. And
zoom out
and take your ego out of it.
Yeah. Yeah, exactly.
Because otherwise you are looking, you get put in jail by a judge that hears the case and is not happy with what happened. And it's like,
yeah,
that was it. And I mean, it's besides the point that the evidence in that case was all on video. Everything was very clear. There was she didn't have any legal argument for what she was doing.
No.
So
it was, not pretty for my client, but that was definitely a lesson learned. I hope for her as well. I don't know, but I don't know if she'll ever have an opportunity like that again, but hopefully she doesn't get in trouble anymore. But I don't know.
It's also a cautionary tale now that you, I'm sure, tell all of your clients, and that I tell clients of mine if they're in that situation, that you don't
ironically
do that.
my second trial with you was also a deferred prosecution agreement offer, and we won that one.
Yeah,
So
that's true.
That
is true.
It's not always a reflection of the case, I would
Right.
say, but, having considered that for the first trial that we're talking about, that was all on video and there was no legal argument. I'm sure if there was a legal argument, that maybe would have been maybe on your radar to outright dismiss it, depending on what the legal argument was and if it was valid or not. But if a crime is on video and the state attorney's office has already filed it and they have no legal reason to dismiss it, they're not going to just outright dismiss it. It makes no sense to do that. And you were basically offering to do that. So that was the best possible outcome aside from the best one is a not guilty, yes. But the process of getting there is so long. Like, this is the best possible outcome without having to do this long, stressful process and risking you
can only get it sealed.
Yeah.
You can't get it expunged.
Yeah.
So the best outcome is that dismissal plus the expungement.
Right.
And that's a Florida thing. If you go all the way to a trial and you are found not guilty, you cannot get your record expunged.
Why
which is
get that expunged?
Really, which is kind of ridiculous.
Yeah.
But I mean, I don't know.
They should freely do those.
It should just be an automatic expungement.
Yeah, because you were proven, they didn't prove that you were guilty, and it's on the state to do that. But I've definitely changed my approach over the years, especially with experience and dealing with so many different clients over the years, different types of clients, people in and out of custody, people who are dealing with homelessness all the way to wealthy clients. There's just a range of people, but at the end of the day, we are all people and we experience the same things, and a lot of the issues intersect and come up, the same issues intersect and come up in certain cases, like domestic. We see a lot of the same family issues over and over again. Yeah, it's different people, but the scenario is pretty much the same every time, whether it's a real battery occurred or not. So there's just so many different ways to actually deal with the client and what they're dealing with. And ultimately, the best way is to just have straightforward, honest conversations up front and making it clear that you are there to be their legal counsel.
And also tell them that if the prosecutor is exercising their discretion in such a way that they're willing to get rid of the case, that they are clearly seeing what you're telling them, which is this is either not as serious or the person doesn't, deserve to be punished to a certain degree, whatever the situation is. But, you have a lenient prosecutor on a situation.
That's definitely a part of the conversation, saying that the prosecutor, just let's even take it to another example where our clients maybe they are scoring on the score sheet. The only person that can depart without having to do a sentencing hearing and without risking, because the court can say, yeah, I find that you are eligible for downward departure and you don't have to serve this prison sentence, but I think you should still do it. And so there's a discretionary component to it, that it's too late at that point after you've already pled guilty or you've already been found guilty. There's a portion where the judge can still say, you're going to prison. I think you should get minimum score, which is X amount of years in prison, versus up front. And okay, will this judge, having practiced in this county, the experience matters. Your interaction with this prosecutor in past cases and seeing them on the daily basis or whatever it is, it matters. It affects all of the cases that end up coming forward. Yeah. I don't want to dismiss facts of the case and how serious maybe the case is, but all those components do come in. And so if you are seeing that this is maybe a better offer, considering the circumstances and the facts surrounding the case and maybe the evidence that was presented to you in discovery, and you do not have a legal argument or factual argument that's so strong, and the prosecutor's willing to amend the charges or depart from the guidelines or exercise their discretion and actually do something good for your client, that comes in the conversation where you're telling your client, I understand you believe this is extreme, but this is a departure from what the ordinary is. This is unusual, or this is not something that happens often. So you should consider this. And so that's definitely a conversation I have had with a lot of my clients.
I think, and something that you touched upon a little bit earlier in this episode, is that the emotions of the attorney and adopting the emotions of your client and then going before the prosecutor or the judge with those emotions, in one sense, can be effective because if you're not somebody that is always emotional like that, a prosecutor that you interact with frequently is going to say, whoa, something is different here.
Yeah.
Or even a judge is going to say something is different here, because there's definitely been cases where, because I don't get emotional on all my cases, but if I am emotional, I think that based on the relationships I've developed with prosecutors and judges, shows that there's something up and there's something different about that case. I have a situation now that when I was in court the other day, I was a little bit more fired up than I ordinarily would be. And I was signaling to both the court and the prosecutor, my position is this strong because I feel this way. And based on what you know of me, you should know, okay, there is something here going on. This is not puffery, and this is not just him always getting emotional because of his clients, that he reacts the same way every time. No, that's not what it is. If I'm getting emotional, there is a specific reason. You need to pay attention. You need to hear what I'm saying and act accordingly, please, because of that.
Yeah.
And that usually works to my client's benefits.
Yeah. And there's a difference between passionate advocacy or zealous advocacy, which I think we both do on a regular basis. And then there's versus being emotional or taking on the client's emotions. And so I just don't want it to people to think that, you're on a regular basis. You always get, basically you're a paper pusher and you have your client sign please all the time. No, we care about the outcome, the best outcome for our clients. But we're not going to put up a fight if it's frivolous.
I don't need to have an aggressive conversation with the prosecutor every single time I talk to them.
Especially
I can have normal, cordial, or even kind conversations with the prosecutor and get exactly what I need out of that, the same way that I would if I was,
I think
even more so than if I was being fakely emotional about it or genuinely emotional,
I agree. I think that the way you present in general, regular pleasantries, I think make a difference. And being fake shows. I think being a genuine good person, you don't have to be best friends with them. You don't have to agree with them. You can still effectively represent your client and say, good morning. How was your weekend?
Exactly right. And smile and have a nice conversation with them. There's no reason you can't do that and still get business done. And you're going to have cases with them again.
And oftentimes we're asking them for things.
Right.
So I don't know, imagine being disrespected by somebody all the time. And then one day you have a really shitty case and you want to go to them and be like, can you please give my client no prison time or jail? And then they're going to be like, you can go F yourself if they want to, they could. So I'm not saying that.
I was in that situation.
Yeah.
There was certain attorneys that were like that.
You definitely don't want to work with them as much as you would be willing to work with other attorneys who are
correct.
Good lawyers and decent people.
I didn't want to work with them. I didn't take it out on their clients, but I didn't go out of my way to do something beneficial for them or make their lives easier.
Yeah. Why would you?
Right.
Exactly. So if you like listening to the show, make sure you comment, and subscribe. Follow us on all platforms. Come back with a warrant.pod, and make sure you subscribe to our newsletter. And if you didn't like listening to us,
come back with a warrant.
I keep forgetting to say 5-star review.
That's all right. You say it sometimes.
Yeah.
Leave a 5-star review and come back with your warrants. Monica and Brandon break down real cases, viral legal moments, and the wild stories they've lived in senior courts. They teach everyday people their rights, unpack the justice system from both sides, and have the hard conversations most lawyers won't touch. This is your front row seat to how criminal law really works.
Lowe's knows how to turn big plans into real results. Whether it's new appliances or a home refresh, get started with 12-month special financing on purchases of $299 or more with a MyLowe's Rewards credit card, January 15th through the 30th. So you can invest in your upgrade now and pay over time. Lowe's, we help, you save. Offer subject to credit approval and cannot be combined. Minimum monthly payment required. See store or Lowe's.com for details.